Thank you very much, Professor Osterveld, for that kind introduction. And first of all, let me say I join you in the acknowledgement you made of who owned the land before we all got here, as well as the project of continuing to review systems, practices, conducts that breed injustice towards Native Canadians, as well as victims of injustice all over the world. It's a great honor and great humility that I join this event today. Now, I will begin by saying disclosures. There are some disclosures that need to be made as well as disclaimers. Now, those I do that. That comes at events like this and circumstances such as this, that it's normal to do that. But I get about it through the story of two justices whom I've admired in terms of their work. One I never met, the second one was in my time. First, Mr. Justice Atkins, many years ago, said that justice is not a cloistered virtue. It must be allowed to suffer the scrutiny and respectful comment of ordinary men and women, I must add. I never met Atkins, he wasn't in my time, but the second person who was in my time was Justice Corey of the Supreme Court of Canada, a man of great empathy and candor. And Justice Corey once was discussing the case he helped to decide at the Supreme Court of Canada, a case called Askov, and in the process of that, he confessed that in rendering that judgment, the Supreme Court didn't quite foresee the fallout that will come out of that. So that the nature of candor also comes in the context of justice. It's not a cloistered virtue. Judges should be able to look at the criticisms and consider their position. Now I come to mine. Some of you know that I was the presiding judge in the case concerning Bashir. The question of immunity was what it was all about. And I presided in that case. Inevitably, when I discuss immunity, that case comes to mind of everyone who knows about it. Now, in the mode of Justice Corey, I'll be candid in discussing it, but to say that it was a fine judgment that was rendered in there. And every time I read criticism about it, I feel that it was the right decision to render. I should say that up front. I will not be discussing the case extensively, but I think I should say that much about it. I'm going to now share a screen of my talk from now on about what this is all about. If you bear with me for a minute, I'll pull up the screen. Okay. So I hope I'm sharing it now. Professor Stavert, can you see this?
Yes.
Great, thank you very much. Thanks. Now, it looks like from what we've been reading recently, especially in the context of the work of International Law Commission, a question arises: are we here dealing with a taboo proposition when one says there is no customary international law for international crimes? Now, the reason that question arises, are we dealing with a taboo proposition, is that in its work, the work of the International Law Commission, they took on the subject of jurisdictional immunities in criminal courts of foreign states. And in it, they produced the special rapporteur produced draft Article 7 which says there is no immunity for customary in customary international law for crimes in international law. And the result was sharp and vigorous protest. We saw unusually heated debate in the floor of the ILC that resulted in a recorded vote, something that's highly unusual in the work of the ILC. And in the end, the recorded vote showed an overwhelming majority in favor of the proposition that there is no immunity for international crimes. 2 years later, the question also was answered by the ICC Appeals Chamber in the context of a case before it about immunity of a head of state. And the Appeals Chamber said there is no customary international law recognition of immunity for international crimes before international courts. Again, the result was what? Sharp and vigorous protest, unusually heated debate on the internet and elsewhere, and an impassioned call for the UN General Assembly to refer the case, the question, to the International Court of Justice in advisory opinion, hopefully for an alternative opinion that will counter what the ICC Appeals Chamber said. And the outcome? No UN General Assembly referral to the ICJ. Now, that leads me to say that, as I began, justice is not a cloistered virtue, but then it must suffer the criticisms of respectful criticisms of and comments of ordinary people, but that such comments can be less sophistry in it will be more helpful, I'd like to say. A long time ago, someone who wrote a classic on how to argue and think was Robert Fowler's, and he said one of his fallacies he identified was that fallacy of confident suggestion, confident assertion. If statements are made again and again in a confident manner without argument or proof, then the hearers will tend to believe them quite independently of their soundness and the presence of evidence of their truth. So that is a crooked way of thinking. That is why in the United States today, there are people who believe without evidence that the current president didn't win the election, the loser won without evidence. Now, that is confident assertion. Again, another trick that happens in arguments. If you cannot answer a man's argument, all is not lost. You can still call him or her vile names, man or woman, that is. And that's the famous author, American author Herbert Hubbard, saying that we saw all of that in comments concerning the Arbor-Shea judgment, but none of that changes my assessment of it as a very good judgment, very comprehensive research involving over 190 pages in joint concurring opinion that reported that research. And many have welcomed it positively, but many have also subjected it to very harsh and negative commentary. But the question doesn't get beyond what is the proof to the contrary of what was decided. So, and I say, after all said and done, the legal conclusion, and in my view, the correct legal conclusion, remains customary international law recognizes no immunity in prosecutions before international tribunals. Now, for present purposes, I'm going to not get into the distinction between the kind of immunity we call ratione personae versus ratione materiae. Ratione personae being immunity that rests on the status of a head of state or an ambassador who represents a head of state in a foreign country. Now, the foreign ministers are said to also enjoy that immunity. So that is ratione personae. That is the highest level of immunity. And the other kind of immunity would be ratione materiae, being functional immunity. Immunity results from somebody who is performing functions of state. And if you prosecute that person, you are basically impugning the state. So I'm not going to get into those distinctions. We don't have time for it, but enough to say that I'm going to pitch it at the highest level of immunity if it exists, and that will be the immunity of head of state, whether there is such immunity before international criminal courts. But first, let's look at the basics. Yeah, customary international law, that's the question, the immunity in customary international law. And customary international law, what is it? The traditional definition of what it is international custom as evidence of a general practice accepted as law. The point being the customary international practice viewed as law compliant, not just something you do because it's a respectful and right thing to do, but because you believe you are complying with the law. That is international custom practice viewed as law compliant, customary practice. Now, why and how come is it that customary international law recognizes no immunity in prosecutions before international tribunals? How come and why? And that question, the same thing, answered by what I'll call certain seismic events that shaped the landscape of international law in relation to the question of immunity. Those seismic events, the first of them was the First World War that resulted in a conference in 1919 called the Versailles Conference. It gave the blueprint to the new international law that we now practice. And that blueprint to new international law involved, for the first time, individual criminal responsibility, international criminal jurisdiction. By that, I mean an international court that had jurisdiction to exercise over violation of international criminal law. And the preclusion of immunity, even for heads of state. So that was the first seismic event. The second occurred 26 years later, the Second World War. These are two great wars when people speak about World War II. Gave us again the Nuremberg that gave tangible form to the new landscape by enshrining the notion of individual criminal responsibility, international criminal jurisdiction, and preclusion of immunity for even heads of state. And what else did the Second World War breed? Integration of human rights into international law, because before then, there was no such thing as international law recognition of human rights to the point anybody could take it up. So if we want to speak of, and that's an abuse of language to talk about silver lining from those two seismic events, but for want of better expression, the silver lining from those great events, seismic events, are these things: individual criminal responsibility, international criminal jurisdiction, preclusion of immunity, even for heads of state, and integration of human rights into international law. Now, from all of that came the response of the policy makers of the time. And what was that response? The response was to say, hang on here, a welter of savagery had been unleashed upon the world in each of these wars. And the culprits of these conducts were sovereign megalomaniacs who had been unhinged by their own dreams of military glory. And enough of the lunacy, said the policymakers of the time. From now on, they said, we will use international law to deter foreign leaders, specifically foreign leaders, from such conduct. And the means to do that would be through individual criminal responsibility, international criminal jurisdiction, and preclusion of immunity, even for heads of state. That was what the policymakers of the time said in reaction to these two events. But today's lecture, again, I'm going to focus on international tribunals. You might have noticed that that's where I'm going, or international jurisdictions. I will not be discussing, getting into, because we don't have the time, immunity, questions of immunity before national jurisdictions. For that, there is a notable development from Germany, because on the question of national jurisdictions, the German Federal Prosecutor General made submissions recently in a case he was prosecuting, and I've already tweeted it on my Twitter handle. You can look it up there, the reference to it, a publication of his opinion, submissions rather, in the Journal of International Criminal Justice. You read it all. I can only pause here to say that as I said in my Twitter, his views were more consistent with international law than those who take the contrary position. And by the way, the views of the Federal Prosecutor General of Germany, what the great Antonio Cassese, those of you who know international criminal law knows that he's one of the big names in the field. He had written an article in the European Journal of International Law in 2002, where he said the same thing, that there is no immunity, even in national jurisdictions, for international crimes. So that is what the Prosecutor General said. And he continued to say that recent discussion in the International Law Commission, or the storm that the world was reading about occurring on the floor of the ILC, do not demonstrate otherwise, right? And this is instructive because in 2017, 3 years before, the German delegate, I think it was the ambassador, had in fact made some statement on the floor of the Sixth Committee of the UN, where he distinctly questioned that proposition. But here we see the Prosecutor General countering that and saying there is no sufficient basis for those who contest the proposition to do so. That is, contest the proposition that there is no customary international law immunity, even in proceedings before national jurisdictions. And all that controversy again results from people whose views were based on incomplete or partly incorrect analysis of the state practice on that point. Now, we have had the opinion of one of Germany's modern leading commentators or publicists in international criminal law, Professor Klaus Kreist, who tells us that in German state practice, what the federal prosecutor says in the course of prosecuting cases before him stands for Germany's state practice, regardless of who may register a different view out of Germany. Now, we're back to the question we're going to discuss from now on. So the point is to say, we're not going to be talking about national jurisdictions anymore. Let's deal with this on a more broader basis. No immunity before international courts. We're going to look at how that law evolved, the origins of the preclusion. I stop here to say this, that the very reason for the existence of the discipline of international criminal law resulted from the need to suppress immunity for international crimes. I repeat that, the very raison d'etre of international criminal law came out of the need to suppress immunity for international crimes. And you'll see that in a minute. And that was World War I and the Paris Peace Conference of 1919, or the Versailles Conference. That was the first occurrence or the precedent for the idea of an international criminal tribunal. Up until that time, the idea of an international criminal court, international criminal tribunal, was unprecedented. It was unknown in international law, but the idea was born in 1919 at Versailles Peace Conference. And that idea came distinctly with preclusion of sovereign immunity. It was wrapped into it, packaged into it. That was the reason why they were talking about creating an international criminal tribunal. Now I see that I may have lost my okay. So it precluded sovereign immunity, and we see that immediately in Article 227 of the Versailles Treaty, concluded in 1919, and that tells us immediately, anyone who pulls it up, that the Allied and associated powers publicly arraigned William II of Hohenzollern, former Emperor of Germany, for offenses against international morality and the sanctity of treaties, and a special tribunal will be constituted to try him, thereby assuring him guarantees essential to the right of defense. That tribunal will be composed of 5 judges from 3 of 4 nations. Now, and the decision of the tribunal will be guided by the highest motives of international policy, with a view to vindicating the solemn obligations of international undertakings and the validity of international morality. Now, let me pause here to say, what do they use? The reference sanctity of treaties, vindicating solemn obligations of international undertakings. This reference contemplates the fact that Germany was signatory to the Hague Conventions, or the first Hague Convention on the Law and Customs of War of 1899. Germany signed it in 1900, right? September 1900. There were also parties to not signed it. Germany ratified it. They signed it immediately upon adoption, but ratified it in 1900. There was similarly a party to the second Hague Convention, the one of 1907. It's not the second Hague Convention. It's the Hague Convention out of the second Hague Peace Conference of 1907. That'll be, in fact, there were about 14 documents adopted, and one of them was the Convention on the Law and Customs of War on Land. Germany was a signatory to that. They signed it in November 1909. A treaty was adopted in 1907, and Germany, ratified it in 1909. So this is the reference to it there. Now, but before we got to Versailles and the adoption of the Versailles Treaty and that provision, Article 227 of the Versailles Treaty, what was the road to Versailles? What was the build-up to going to Versailles? And I would say that road to Versailles was paved with determination to exact accountability and reject sovereign immunity. It was a firm determination to do those things. And we will see that immediately in the work of the Macdonnell Committee, 1918 in the UK. It is a mistake, I insist, for international jurists to ignore that work of the Macdonnell Committee as if it's a footnote in history. It is not a footnote in history. It was a big sourdough in the making of the international law that we enjoy today. Now, we're going to look at some pages out of the report of the Macdonnell Committee. The interim report has in it some very revealing remarks and observations. We're going to look at that. We're going to spend some time looking at this. The pages you see on screen, copies of that document. And we will be looking at the opening of the work of the committee on the first day of their meeting. Sir Frederick Smith, KC, that's King's Counsel, the Attorney General of England and Wales at the time, addressed the committee. And what he said on that occasion is truly important and very, very revealing. Let's look at that. He begins by this in the highlighted text in green. In our municipal laws, punishment waits upon the wrongdoer, and the presence of punishment, immediate, inevitable, is one of the primary and essential marks of a civilized community. All of us have been familiar, all those who have contributed immeasurable industry and great learning to the gradual evolution of the doctrine of international law, have been well aware of the weakness of international law upon this point, that's on the point of punishment for breaking international law. But they, that is those who've been spending time developing and studying international law, but they have been content to believe since the day when the genius and the humanity of Grotius, Hugo Grotius that is, first created the foundations upon which the great doctrines of international law were to be built, that there would never be such a retrogression into savagery, that any great community would challenge these doctrines with the result of flinging the whole world back from civilization into a welter of savagery. Gentlemen, that challenge was made. As I have said, happily and providentially, with how narrow a margin of success few, even of those who are here, know completely. Only those can know completely who have partaken of the immediate secrets of the government in the last 4.5 years. It has failed. It has definitively failed. That is the challenge. And the question now has arisen, and this is very, very important. The question now has arisen, what steps ought to be taken, not for the purpose of wreaking any spirit of idle vindictiveness, but for the purpose of re-establishing the authority of international law. I hope, gentlemen, I believe that we say, as we say today, that we are determined. We're determined to take any steps that are necessary to reassert and to reassert under the circumstances of the utmost possible notoriety, the authority of those doctrines that we say so, not in the spirit of men who want to be vindictive. Right here, you see him say, there's been a vile challenge to international law by a regime that thought international law was always weak. That challenge as narrowly was defeated, but now we're going to use this opportunity to ensure the authority of international law. And he continues in the passages highlighted below. And that's again important. There he says that he wants to be sure that their children and grandchildren and those who come after them shall be spared what this generation has gone through. That is a determination, ladies and gentlemen, into directing international law in a new course. That was what Sir Frederick Smith was communicating at that meeting. And he talks about, to what it seems that the most effective way to do that is to ensure that for all ages, any leader who is tempted to follow the same path, the wicked path that was followed by the governors of the central powers during the last 4 years, shall have to think, not have in mind, not only a picture of military brilliance and meretricious glamour of military success, but also the recollection that in this great conflict, punishment attended upon crime. So there again, say, we want to be sure that in future, anybody who tries this in future would have to not only think we are just going to use power and bamboozle everybody, they need to think that there will be punishment awaiting them immediately for crimes they commit in that kind of adventure. That was what Sir Frederick Smith was communicating. That was the determination on behalf of the United Kingdom's government. That was their determination. That, ladies and gentlemen, should not be elided in pages of history. It was an important development. So that showed again a determined act in social engineering at the global level. Point being, enough of the repeated sport of strongmen scornfully trampling upon international law, perceiving it as weak. The World War I was to be a game changer. Thenceforth, UK and France, we'll see later, were determined to give some teeth to international law, and that teeth to be given was in the form of immediate and inevitable punishment for those who commit crimes against international law, even if they are emperors and kings, and there will be no immunity recognized for them. That was the message that Sir Frederick Smith was communicating. We'll see that was the message in France. So Frederick Pollock, another Frederick, but Pollock this time, a member of the committee, an eminent jurist of his time, in concurring opinion to the Macdonnell report, observed as follows: the questions before the committee are unique in more than one way, and one of the ways in which it's unique is this: the jurisdiction is without precedent. History furnishes no example of a tribunal established by several allied states to do justice on offenders against rules and customs equally recognized by all of them. In other words, the idea of an international court is without precedent in 1918. Now, what significance of that observation, that this new international tribunal being without precedent, what is that? It is that any rule of immunity earlier recognized before national courts would not apply to this new kind of tribunal that had thus far been without precedent in international law, because those rules were made to guide the work of national courts, not an international court. Why the need for, again, an international tribunal? Why? And we see, again, the answer comes in the report of the Macdonnell Committee. One, these are quotes out of the report. On the whole, no English court administering the ordinary criminal law would have jurisdiction to try the offenses being contemplated. It seems to us that the trial of the Kaiser ought to be by an international tribunal, free from national biases, and whose decision would have unquestionable authority, which would speak in the name of the conscience of the world, and it will be established to strengthen international law in the future, and it would deter and be a deterrent warning to rulers and highly placed officials. Again, that it would have the effect in the future. It would be a deterrent and warning to rulers and highly placed officials who mediated or instigated offenses against international law. And they continue again, another quote: the vindication of the principles of international law which the Kaiser had violated would be incomplete were he not brought to trial, and the trial of other offenders might be seriously prejudiced if they would plead the superior order of sovereign against whom no steps had been taken, and that it will be inequitable to punish lower grade officials and allow the sovereign who had ordered their conduct or condoned it to go without sanction. So those are the reasons why the Macdonnell Committee thought the solution lied with international law. Lay with international law. Meanwhile, in France, we see another development happening. We see that in the work of Ferdinand Larnaude and Albert Jouffre Delapradelle, both of Paris University. Larnaude was the dean, and Delapradelle was a professor of international law. And they published a monograph commissioned by the French Ministry of Defense, Ministère de la Guerre, titled Examen de la responsabilité pénale de l'Empereur Guillaume II. And in it, the one thing we take out of that, we're not going to go through the whole monograph, but summarize it. But one thing that comes out of it is this apostrophe you see here, on droit international nouveau, a new international law is born, they say, or is established. What are they talking about? In the report, they say that a tribunal must be found by its composition, the position it occupies, and the authority with which it is clothed will deliver the most solemn judgment the world has ever seen. A way must be found to permit all acts of which he, that's the Kaiser, has been guilty, to be addressed, because he ordered them as supreme warlord. International law alone can supply this way that must be found. The facts charged against William II are international crimes to be tried before an international tribunal. And modern law does not know irresponsible authorities. Even at the apex of hierarchies, the state must be taken down from pedestal and subjected to the decision of the judge. Therefore, there can be no debate about exempting from judgment the man who is at the summit of the hierarchy. Again, these are important words. Again, it would be a mistake to confine historical footnote these kinds of work that were part of what I call the sourdough of international law that we have now in practice. So those were the setup, the road to Versailles, the work of the Macdonnell Committee in the UK, and the study done by Larnaude and Delapradelle for France. With that, off to Versailles they went. And at Versailles, we will be reviewing the work of an important commission called Subcommission, famously called Subcommission number 3. It is a subcommission of the wider commission on the enforcement of penalties and authorship of the war. Now, a commission, but a subcommission number 3 did the work we're going to consider in the relevant respect that resulted eventually in the adoption of Article 227 of the Treaty of Versailles. And that the work of the subcommission, the history books would tell us, involved a grueling dogfight, and you'll see it in a minute, a grueling dogfight. Mark that concept. Now, here's the introduction. Here's a from the U.S. archives. Again, these are real documents, the microfiche of the minutes of the work of the subcommission's work. Here's a report. We'll be looking at the first draft report that subcommission number 3 was presented with. Presented draft report right on the 4th of March, 1919. That draft report dealt with the question of the court for the trial of violations of the laws and customs of war. Again, draft, very first draft. You'll see something here. In it, there's a certain formulation in paragraph 4, that's Roman 4C of the report. And here is what it says. Contemplating the court that would do the trials, were conduct inquiries or trials against the ex-Kaiser himself, insofar as he ordered or abstained from controlling and mitigating the barbarities committed. Now, at this stage, you will note that its reference was to the Kaiser, but there's nothing beyond that about heads of state, just the Kaiser himself. You will see how this changes. In the second iteration or subsequent iteration of the report, this is a draft report as adopted by the subcommission on the 8th of March 1918. We see a certain formulation. Now, the part being highlighted in blue was an insistence that the subcommission had the authority to inquire into the kind of court that will be established to try the offences. The reason for that was later on we'll see about certain objections. One of the objections that Robert Lansing had made was that the subcommission had no authority to look into that, but he was outvoted on that. In the end, the subcommission said, yes, we do have the authority to do that. And that's what we see in the blue highlight. But for us now, the more important thing is what comes later. Here we see the acts constituting violations of the laws and customs of war. These are offenses you'll see, or violations you see taken from the Hague Convention number 4 of 1907, the Convention on the Laws and Customs of War on Land. These are a catalogue of violations taken from that document, mostly from that treaty. But we're back to the, again, second iteration of the report, contemplating the court for the trial of violations of laws and customs of war, and tells us that this is a recommendation of the subcommission. They recommend that enemies alleged to be responsible for the outrages catalogued in the preceding paragraph should be tried before an appropriate tribunal existing or to be set up in each of the belligerent authorities. So here we see the idea that states have the authority to try offenders in their own national courts. You can try foreign offenders, the enemy soldiers, in your own national court. That's what's in the blue paragraph. But then it continues to say that, but there remains, however, a number of charges for which it is appropriate that an international tribunal be set up, and that tribunal will engage trials against, here's the formulation. Now we compare this to what we saw earlier, the first formulation. Here is the second formulation. The eventual formulation will be inquiry or trial, prosecution against all authorities, civil or military, belonging to enemy countries, however high that position may have been, without distinction of rank, including the heads of state who ordered or abstained from preventing, putting an end to, or suppressing violations of the laws and customs of war. Here, a specific reference to heads of state, and they removed the reference to Kaiser, replaced it by including heads of state. And that trial, they said, needs to be done, in the opinion of the subcommission, by a high tribunal, which is essential and should be established according to the following plan. Now, here comes the dogfight after that. So that formulation we saw, second iteration, was presented to the subcommission number 3 in their meeting of the 8th of March 1919. And that dogfight was between Robert Lansing, the US Secretary of State, and the chairperson of the subcommission, versus Ernest Pollock, not Frederick Pollock. This is the cousin of Frederick Pollock, whom we've seen before. Both of Pollocks, by the way, were members of the committee. But by this point, Ernest Pollock had gone on to become the Solicitor General of the United Kingdom, or the England and Wales, and vice chair of subcommission number 3. So there was that dogfight between the two men, Lansing and Pollock. How does it unfold? Chairman here, minutes, refers to Lansing, and we see it brewing. First of the plug, remember he had already lost the first attack to say the subcommission should not look into establishing a court, and he lost that fight. So here's tag 2 for him. So after reading that text, they said, including heads of state, what does he say? He said, I, quote, I find a certain measure of disagreement in regard to item C. I referred to the beginning of Article 4, in which a catalogue is given of charges against certain persons. Item C reads as follows: against all authorities, civil or military, however high their position may have been, without distinction of rank, including the heads of state who ordered or abstained from preventing, putting an end to, or representing barbarities or acts of violence. We saw that already. Here, Lanson is objecting to it. And a registered objection. What does it say? My first objection to that item is that the phrase including the heads of state, he objected to the phrase including heads of state because it is, what does it say, superfluous and therefore needless. It raises the issue at once, or rather, it commits this commission at once to the right to try sovereigns of nations. Under this article, the President of the United States or the King of England might be tried for having failed to prevent certain of their soldiers from performing barbarities or atrocious acts. Now, I am not prepared to place the President of the United States in a position like that, but that is the way it reads, and I think it is a pretty serious position. Objecting to the right to try sovereigns of nations by an international court. Now, and right off the bat, Pollock moves in. So Ernest Pollock, quote, Mr. President, I am sorry to say that I could not accept the report if these words were deleted. To my mind, they are not superfluous, and I think they are not superfluous for this reason. I mean, on behalf of the British Empire. Again, at that time, the British Empire in 1919 was a very vast expanse of place. I mean, on behalf of the British Empire, to include the possibility of a charge against the sovereigns of states. And I think the view of the United States, which you have expressed quite frankly, and from information which you are now possessed of, is not to include a charge against the sovereigns of states, and therefore there is a marked divergence between us. And as I intend on behalf of the British Empire, we intend, my colleague and myself, that the sovereign of a state should be put on trial. For that reason, I think it cannot be said that the words are superfluous, because it is necessary to express what we mean, to make it quite clear, and not to allow anyone to suppose that by assenting to the deletion of these words, we have agreed to a course which it is not our intention to agree to, and therefore, on behalf of the British Empire, I must ask that these words be retained. So there he presses it in. It's not an accident. It's not an oversight. We intend to indict sovereigns of states if they do these things. That is what we intend. And if we mean it, we want it in there. That's what Pollock is saying. And in the last highlighted passage, he talks about how he was not impressed by the argument on Lansing about the President of the United States, the King of England. And in the next passage, and then there he goes, that if the President, like it is still Pollock, if the President of the United States had been in any way guilty or responsible for the acts which we attribute to William II, I believe the United States would be perhaps the most insistent that a president guilty with such blood guiltiness upon him should be brought to trial, and the mere fact that he happened to be the President of the United States would not protect him from the execration of those persons who elected him to that high and responsible position. In other words, a criminal guilty person who is responsible for what he happened in the course of the war, be he the President of the United States, or be he the King of England, or the King of any other country, deserves and should receive, not only from the United States, but from every country, the condemnation which he ought to receive. So that is Pollock digging in, say, we're not impressed by you flashing the picture of the United States President on trial. Here we insist that he must be put heads of state, sovereigns must be put on trial. So this is the origin of this. And then when Larnaude moved in himself, he spoke in French, and he insisted that immediately that he was in complete agreement with what Pollock had said. And Larnaude insisted that it's not enough to leave it at mere authorities. He insisted that they need to be spelled out, because if you left it at authorities, heads of state might escape, because there are many authorities that may not include heads of state. He said, we have to insist on heads of state being in there. So these are some of the early takes, and Larnaude continues in the next passage. What I will do, we don't have a lot of time to go through all of this. After this lecture, I'll try and provide a link to these records, historical records. I'll put it on my Twitter. I try and do it if I can manage technology to do that, so those who are interested can read it for themselves. There was a determination to say, we intend that sovereigns of states must also be put on trial. Now, I'm going to move forward here because we don't have time. So the end of it is to say that Lansing lost that fight in the end, that dogfight, and Pollock won it. And in the end, the commission made the report, and it said that they were not impressed by the objection of the Americans. And the Americans issued a dissenting opinion, a minority opinion joined in by Japan. And the rest of the members of the committee voted to proceed to indict sovereigns of states, including the highest authorities, including heads of state. 26 years later, what do we see? This is very important. London Conference, 1945, again, the end of Second World War. In this London Conference, to try and set up the trial, the Nuremberg trials, we see the United States directly reversing Lansing's Versailles stand. At that point, the world had decided we're going to indict even heads of state who commit war crimes. It was a majority decision out of Versailles. By the time the big powerful state that was against it was United States. By 1945, the US now had come around and directly joined, this time with Robert H. Jackson leading the charge in establishing the Nuremberg Tribunal. And the important thing with Robert Jackson was in a report he wrote to President Truman in 1945, he directly dealt with the question of immunity, beginning with outright repudiation of Lansing's position here. He's observed saying on a point, not directly on this, but generally on Lansing's position, he says, I must say that sentiments in the United States and the better world opinion have greatly changed since Mr. James Brown's court and Secretary Lansing announced their views as to the criminal responsibility for the First World War. And he continues to say something that should interest us. He says, I have no expectation that any rule we could formulate would avoid criticisms of some scholars of international law, for a good many of them since 1918 have learned nothing and have forgotten nothing. This is the more important thing for us now, is this repudiation of Brown's court and Lansing's position. James Brown's court was the second member of the US on subcommission number 3. So he's saying we no longer agree to that. And what does he say? Now, in the report, he deals squarely with immunity. And he deals with the kinds of defenses that should be available and should not be permitted. And the one he says was here, nor should such a defense be recognized as the obsolete doctrine that heads of state, a head of state is immune to legal liability. There is more than a suspicion that is a relic of the idea of the divine right of kings in the United States. We don't accept that anymore, he said. and continuing that it is we do not accept the paradox that legal responsibility should lie the least where power is the greatest. We stand on the principle of government declared some 3 centuries ago to King James by Chief Justice Coke, who proclaimed that even the king is under God and the law. So that's, in a nutshell, repudiation of Lansing's objection on the ground of trying heads of state. Jackson is saying, no, heads of state must be tried. And that was the latest we had on that. And that's what now spurred us to where we are. We now have preclusion of immunity for heads of state coming out of Nuremberg judgment. The Nuremberg judgment directly dealt with that and flatly said, no, we do not accept that. And following the Nuremberg judgment, the UN General Assembly first of all, adopted a resolution 95, first session of the UN General Assembly, 95 in bracket 1, where the General Assembly directly affirmed the principles of international law. In other words, we are affirming the principles of international law that resulted from the Nuremberg proceedings. Having affirmed that in very specific way, the General Assembly then directed the UN International Law Commission in both Resolution 95-1 and a subsequent Resolution 1772 to formulate those principles, to formulate them. And here I'm going to not follow the slide anymore, run to the end because we're out of time. I want to give you an opportunity to ask your questions. Now, the UNGA directed the ILC to formulate the principles of international law that came out of the Nuremberg proceedings. Again, not an accident, because Truman had wanted that to be done. And at the first session of the UN General Assembly, the second part of the first session, and the first secretary of the UN, Secretary General of the UN, Trevelyan, in a report he issued on the second day of that meeting in 1946, said we have to distill the principles of Nuremberg and it's essential to distill them and make them a permanent part of international law, a permanent part of international law. So in the result, the UN gave ILC the task of then formulating those principles. And in their work, very quickly, somebody asked in the floor of the ILC, well, the UN has affirmed this thing. Shouldn't we be asking ourselves whether these are principles of international law to begin with? And by a majority, the ILC said, no, it is not our mandate. The UN has already affirmed those principles. We cannot go back on that. Our job now is to distill those principles of international law. So that was the task of the UN ILC. Let me stop sharing the screen here because I'm not following it anymore. If someone can help me stop this. 1 second.
Julie,
All right,
yeah, it's working.
Thank you very much. So the point being here, the ILC said, well, it's not our job now to go behind the UN to inquire whether the principles that were in Nuremberg were principles of international law to begin with. The important thing is that the UN has said, we affirm those principles. ILC, your job is now to go ahead and distill them. What are they? So in the result, in 1950, the ILC produced what they call a set of principles of international law that came out of Nuremberg proceedings. That's what we call the Nuremberg principles. Now, I pause here to say this again. I would have shown you the slides, but because of time, I'm stopping to just run it through without the slides here. The interesting thing often is asked the question, well, oftentimes in the work of the ILC, we hear principles, general principles, guidelines, and all that. We don't quite know what these principles are about. Are they general principles, principles of morality, or principles of international law? Now, the job that the UNGA gave to ILC on this specific question was about distilling principles of international law. And the two resolutions specifically say that. And when the ILC were reporting their work in 1950, they also say that. And in the work, the Nuremberg Principles does say these are principles of international law distilled from the Nuremberg proceedings. And principle one is that anyone who commits international crime shall be punished for it. That's the first principle. And we go to one that concerns us here. Principle number three, they said, whoever commits international crime shall be responsible for it, even if he or she is a head of state or high government official, then again, specifically naming head of state. And we see now, from then on until now, that concept repeated in all instruments. We talk about general practice, recognized as law, being customary practice. It has become customary to see that norm formulated into the basic documents of international tribunals and internationalized tribunals. We see it in the document produced by the statutes of the International Criminal Tribunal for the former Yugoslavia that the UN Security Council formulated on behalf of the UN. We see it in the statute of the International Criminal Tribunal for Rwanda. We see it in the statute of the Special Court for Sierra Leone. We see it even by the AU's own statute in the courts of Senegal to try his and Habre. That principle is there. We see it in the special court for the statute of the Special Court for Kosovo. We see it in the work of the East Timor Specialist Chamber. We see it in the work now done in the i.e.Preclusion, the Cambodia Specialized Chamber. So it is customary to see that concept repeated, and that is customary international law. It all came out of the two seismic events I talked about that shaped the new landscape of international law that we have it. Now, anyone who now in this day and age wants to argue that there is immunity falls afoul of what Jackson said of academics in 1945. It looks like many of them have learned nothing from 1918. It looks like many of us academics have learned nothing from the First World War, from the Second World War, from the Rwandan genocide, from the Pol Pot's regime in Cambodia, from the Special Court for Sierra Leone, from all the atrocities where, when you today bring out those who are leading the regimes implicated in these crimes, you will be hard-pressed to boldly stand firm and justify your argument of immunity without falling afoul of Mr. Bumble's chiding of law. We all remember that. Mr. Bumble, if the law supposes X, then the law is, excuse the language, an ass, because that's the language used by Charles Dickens there. He was responding to the proposition that, well, because his wife did something illegal, he is responsible for it because his wife, the law presumes that his wife is under him and follows his directions, and Bumble pounded the table, saying if the law supposes that, then the law is and the law must not have been a married man. The question then is, if the law supposes that Hitler, that Charles Taylor, that Theonest Bagosora, who was the effective head of state of Rwanda during the genocide, that Pol Pot should all enjoy immunity, then the law is flip, then the law must not have been the victim of gross violation. But ladies and gentlemen, I need to wrap it up quickly, and hopefully some of these things will come in form of question. One thing I want to do here is something I wouldn't do normally, but now that I'm academic, I have freedom to do things. The judgment hasn't rendered in the case, and I'm not commenting about that. That's part. But now moving forward, broader questions. This debate needs to come to an end. And it's not enough for people to, be writing these things from the ivory tower of academia. There comes a point where people need to put their mouth in it. And this is something I'm gonna throw down a challenge here, a challenge for a good cause. Maybe some charity can get benefit from this endless debate, tedious debate, in my view. To end the tedium, I'm going to say this. If any of those academics who are on the opposite side of the proposition that customary international law does not recognize immunity, if any of them can step forward, I'm prepared to do this. $5,000 for any who can show a gathering of international law where states gathering together since 1919 voted to recognize immunity for heads of state for violating international crimes. Anyone who can show that research where states in multilateral gathering say, yes, we are going to recognize immunity since 1919, I'll donate $5,000 to the charity of that academic's choosing. But if that academic steps forward and cannot prove it or show such, he would have to donate $5,000 to a charity of my own choosing, which would be the Trust Fund for Victims of the ICC. And I will have to leave it at that for now, and hopefully be able to pick up some of the remaining matters during the Q&A. Professor Osterwell, that's it from me. Thank you very much.
Thanks so much for that true tour de force through the law of immunity before international tribunals. You've taken us through a full century and back in just an hour. So that was quite remarkable. And I'm sure that you've raised many questions for the audience that would be great to talk through. We already have some coming in, and I welcome our audience to add to the Q&A to raise any other questions that they might have. And so I'll start one question from Lisa Van Every, who asks, what do you think contributed to the United States changing their position to agree with immunity against the immunity of heads of states in 1945? What was behind the shift, do you think, from 1919 to 1945 when it came to the US representatives negotiating the institutions that were created?
Thank you. Of course, it would be too much to speculate in what was the mind, precisely what was in the mind of Mr. Justice Robert Jackson. I take it from what he said, and he was very firm in insisting that there must be no immunity. He said that in the report, and we see that in Article 7 of the Nuremberg Charter, specifically that in that formulation, no immunity, even no absolution from punishment, even for heads of state. I think you had some of, we can only guess at what was in Jackson's mind at the time, but we know that over the years, while the war was ongoing, FDR was the president at the time, and he was determined that there would be punishment. He made statements to the press, issued press releases. I remember one of his exchanges on this was, I think, Fireside Chat, I think number 24, I might be mistaken about the number, but one of them, in which he insisted that at the end of this war, those who committed atrocities will be tried before the courts of justice. This is FDR. So he was determined, and he to exact punishment, and the Russians agreed with him. That would be the case, right? And Charles de Gaulle, if you remember, had flown into exile, leading French government in exile, and a captive government was running France at the time. So he was not surprised. It was unsurprising at all that at the end of the war, given what people suffered, including, let's not forget that, the big issue of the Holocaust that happened. It was not, you could see how, and it would make sense for Jackson to come around and say, okay, enough of this thing. There has to be a trial. Forget what Lansing and James Brown's court were saying in 1919 in Versailles. We're not with them. We insist that it is we cannot accept the paradox that responsibility lies the least where power is the greatest. Heads of state who do these things must be tried. The events, I would think, spoke for themselves. And by then, I would say the template that was given in 1919 had 26 years for people to ruminate about it. It was the first time anyone thought about it in 1919. And it was, to some people, a revolutionary idea. But by 1945, it was no longer a revolutionary idea. It seemed like the only sensible thing to do, and they did it.
Thank you very much. I have a question for you, which is this. Some commentators have lauded the ICC Appeals Chamber judgment, and some have critiqued it, as you've already noted. One of the complaints is that the Appeals Chamber should have avoided engaging in a discussion of customary international law on immunity. What is your response or your views?
Thank you very much. It's one of those questions I would love to answer, and I asked you to remind me of those. Definitely, the problem with it's quite frankly a startling critique, right? The pre-trial chamber did not avoid the question, and there was no avoiding the question before on the case before us. Here you had the Rome Statute, Article 27, saying there is no immunity for anyone. And you had Security Council Resolution 1593 that referred the case to the ICC, said nothing at all about immunity. Silent on immunity from UN resolution, Security Council resolution, and ICC statutes specifically banishing immunity. And yet you have someone saying, well, we could not arrest al-Bashir when he was in Jordan because he enjoyed immunity. What immunity are we talking about? Where would that immunity come from? That was a critical question. And how did pre-trial chamber deal with it? Pre-trial chamber said, well, we know that, by the way, a previous pre-trial chamber 1 in the Malawi case and Chad case had decided that there was no immunity in customary international law. But pre-trial chamber 2 changed that to say, well, we are aware that there is something called immunity in relation to courts of national states at the horizontal level. Sovereigns enjoyed immunity in the courts of one another. And so that's premise number one. That's the first step of pre-trial chamber's reasoning. So right there you say, yeah, they recognize there's immunity. And what do they say next? And say, we are not aware, again, it's about their own awareness, we're not aware that that immunity does not apply to international courts. They're not aware. All right, and then they said that that's the second stage of reasoning. The third stage of reasoning was, well, the only way to get around that immunity is to interpret the UN Security Council resolution as putting Sudan in the same situation as a state party to the Rome Statute, and then say Article 27 doesn't apply. Ergo, Bashir does not enjoy immunity. Well, in my view, that was like a band-aid to a fundamental question. The pre-trial chamber already said, well, we know there's immunity somewhere. It's not clear to us that it doesn't apply here, but we have to get around it. Well, at the crux of that was immunity. And the question was, what immunity are we talking about? Now, the fact that the pre-trial chamber was not aware of that that's the awareness of the pre-trial chamber, not the awareness of the appeals chamber. So when the matter came up, the appeals chamber had now to inquire into its own awareness to ask whether there is immunity to begin with. And the answer was no, there is none. From the appeals chamber's own awareness. And the report is the research is fully reported in the joint concurring opinion of 4 out of 5 judges. So to solve it by saying, well, we're going to say, let's get around it and just do a Security Council interpretation, would be to solve an immediate problem for the ICC, but create a much bigger one for the ICC in other cases, as well as other international courts in future in other cases. So that would be a very serious problem, and the appeals chamber did the right thing, in my view, of saying we have to look into this question. Is there or is there no immunity? If there is immunity, where could that be found? The only place to find it would be in customary international law. The chamber said, well, let's look. And the appeals chamber looked and said, no, we don't find that immunity. And we didn't leave it as, sorry, when I say we, I'm not speaking on behalf of my chambers here, but the appeals chamber didn't leave it only in terms of saying, well, those who want to prove the existence of that kind of immunity, who assert it must prove it. The point was made, it has not been proved by anyone. But beyond that, the chamber said, well, we're not going to leave it at simply those who assert it have not proved it. In fact, we are going to say that the research shows that there is no such immunity. There have been positive acts rejecting that immunity since 1919 up until the present day. So that was the research you saw in that. So it's not enough to, in what have been, quite frankly, a very strange approach to say, well, we're going to circumvent it and use an artificial reasoning to avoid the question, because 2 years earlier, it had blown up on the floor of the ILC in another context. So let's not go there so we don't get attacked like the special rapporteur was attacked in the ILC. No, judges must do their work and let the criticisms come. So people appreciated the work, others didn't like it. So, but that's the nature of the job. Thank you.
I've got one provocative question from the audience that I want to raise for you, and then I'm actually going to have to step out of the Zoom room into a real classroom. So I wanted to say thank you again, and Valerie will give our final thanks in just a moment. But the provocative question from our audience member is, in trying to figure out the state practice that composes customary international law on point, how should we make sense of the practice of states in refusing to cooperate with international tribunals, especially the ICC, in the execution and implementation of orders regarding authorization to arrest or condemn officials, heads of states? Should we make sense of that modern behavior as simply unlawful behavior that breaches an existing customary norm, or is that state practice that establishes a customary norm of a different sort? So that comes from an anonymous attendee in the thank you again.
Thank you very much. There's a number of ways. It's a very big question, obviously, but you cannot, in my view, deduce, customary international from silence. There could be a number of reasons why you'd be silent about something. It could be your friend or your interest engaged, and you don't want to speak too much about it. You look the other way and pretend it's not there. The deduction of customary international law comes to the greatest clarity with positive statements about it. And as I said, in that challenge for a good cause that I put in there, the best way to gauge state practice is what they do when they gather together, not what they do in different places. You don't know why they're doing it, but when they're in one room and they're dealing with a specific proposition, that is the best gauge of state practice on that specific point. What do they do on it? And I'd say anytime states have gathered together on this and the question arose, what did they do? That is the best gauge of state practice, not what people didn't do or, being vague about some of the things. Some of those things could be born out of illegality. Some of them could be born out of national law and international law tells us you cannot use your national law to basically upset international obligations and all sorts of reasons. So a silence or refusing to arrest Bashir cannot be state practice on this question of immunity.
Thank you very much. There's one more question which I will ask you. I know, Ryan, you need to leave, so disappear from the screen. The last question that we have from the audience is, after the ICC Appeals Chamber decision, did the ICC see increased compliance with its requests for cooperation as far as you observed?
The candid answer to that, frankly, is I didn't check to see that. That's certainly interesting thought, but the question of compliance was always a difficult thing. Again, you don't know why states don't comply with many things. Some of them are very, very basic. I remember one case, one trial I was involved in, and we wanted to get a witness to come and testify. A witness who's already been relocated from a certain country, who claimed refugee status in the Netherlands. And it was like, again, dogfight to get him to come in. Not on his side. It was now the government of the Netherlands, very supportive of the court and all that. It felt that, well, there is certain protections, obligations we also have under the refugee status. This person has claimed asylum, so we also have to be very careful in how we maneuver all those things. So again, different considerations. That was something I saw myself. You would have thought that if it was in Canada, you would need a witness. Just the police would just go and pick them up and bring them to the courtroom, and they'd give their testimony. But here it took about 2 weeks and more, and we're still negotiating how this would happen. And that from a state that's very, very compliant, whose territory the court was. So you don't quite know when we talk about compliance, the backstory and the fullest picture of it. Yes, for us of the ICC, yes, we are. Of course, when the court issued an arrest warrant, we want states to carry it out. But for a lot of states, they might say, okay, we know, but well, let's think about this and some of that stuff. So the short answer to that question is, I really haven't done that inquiry.
Well, I'm going to take the opportunity now to thank you so much, Dr. Eboe-Osuji, for giving Western Law's third annual International Law and Global Justice Lecture. And I must say, I've never been in a lecture that ends with a $5,000 challenge to academics around the world. So I suggest that you also tweet it out so that your challenge is out there and see who is willing to take you up on it. It was an exciting way to end your lecture. Thank you again, and thank you again to everyone who has attended. Take care.
Thank you very much. Bye-bye.